Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, can robots collude? Understanding the competition implications of artificial intelligence. Artificial intelligence 25 years ago seemed like a science fiction concept, but today it has advanced, so it's actually an integral part of many of the things that we touch on a daily basis. And whenever there are these types of developments, they have sometimes unexpected impact on competition, on privacy, on consumer protection. Today we're going to talk about how artificial intelligence can implicate competition law. My co-host today is Ricardo Woolery. Hi, Ricardo.
Hey, John.
Ricardo, what are we doing today?
So as you previewed, today we're going to talk about the impact of advancements in artificial intelligence on enforcement efforts by antitrust and competition regulators, and the impact of advances in artificial intelligence on the kind of exposure that companies face when a lot of their competitive sensitive decision making and practices are driven by AI.
Who is our guest today?
Our guest today is Kelly Smith Fayne. Kelly is an antitrust associate at the law firm of Latham & Watkins, and Kelly advises clients on government reviews of mergers and acquisitions, antitrust compliance and counseling, and government conduct investigations. Now, I want to mention one more thing about Kelly. Kelly is very involved in the ABA, where she is, and she's also the senior editor of the Antitrust Law Journal.
And what are we hoping to get out of today's program?
So I think we'd like to get at least three things out of today's program. First, we want folks to have a better understanding of why artificial intelligence technologies are relevant to competitive conditions in markets for certain products and services. We also want folks to get a better idea of the challenges that regulatory agencies face when they're thinking of their enforcement policies and strategies in cases where artificial intelligence, not humans, drive some of the decisions on pricing and output and innovation. And third, we want folks to get a better idea of the key takeaways that companies need to use to adjust their compliance policies to mitigate their risk of violating antitrust laws when they use AI.
Well, let's bring our guest, Kelly Fayne. Welcome to the program.
Hi, guys.
Hey. All right, Kelly. So let's start with the first question. Basic question, but a really broad question. So, I've heard a lot of terms thrown out there to describe various technologies like machine learning, deep learning, algorithms, predictive coding. Now, I know that these all describe very distinct technologies, but for the purposes of this conversation, I'd like to narrow it down to one broad umbrella by the name of artificial intelligence. So, at its core, can you describe what artificial intelligence is?
Sure. So, so one way to come at that question, right, is to think about why is AI interesting in an antitrust context. And I think there, if you kind of look at the core of the fundamentals of modern antitrust, it's this kind of economic framework or microeconomics framework where the question is, what does a rational profit maximizing actor do based on the data and the inputs and the markets that they're operating in? And the problem with that question, and the problem that's been for a long time, is that nobody is a rational profit maximizing actor. And everybody has to use heuristics, and they have kind of behavioral economics tells them that they do things that are not rational. And so then you introduce AI, and all of a sudden you have this perfect profit maximizing rational actor in the form of a computer and an algorithm. And based on what your technology is enabled to do or asked to do, you can ask it to go out there and get the best price for a product. Or you can ask it to find the customers who are most likely to buy something. Or you can ask it to observe all of the inputs that you would in an ideal world if you were just kind of out there on your own, walking through your competitor's grocery store, pick up all that information, ingest it, and make decisions based on it as quickly as possible and way faster than humans can. So in a certain way, what AI does is it gets us like closer to the textbook economics that we've all been kind of basing this entire antitrust experiment on for years. At the same time, I think, that presents a whole host of new issues, both kind of highly theoretical, like whether robots can collude with one another, and highly practical, which is how do you kind of help companies navigate a compliance regime where your algorithms are themselves often the kind of the tool with which you can explain how you've made all your decisions over the past several years.
That's fascinating. No. Let's take a step backward, because you've raised some of the pluses and potential minuses that AI imposes on antitrust law. But at a very basic level, what are some of the business practices and decisions that are more likely to draw the scrutiny of antitrust and competition regulators when companies use AI?
So can we start with a really kind of fun theoretical question,
Sure.
which is, can robots collude with one another? And I think when we talk about algorithmic collusion, there's kind of different flavors of it, right? There's the very basic flavor, the one that's already got an enforcement action, where the poster child for algorithmic collusion is actually a case about posters. And there, it's just this very simple, one company agrees they're going to use an algorithm that looks at the other company's price, and then vice versa, and that kind of results in a collusive outcome in an enforcement action. That's like the super easy case for this, and it's not really any different than, in 1922, two people just agree that they're going to use the same math formula for pricing. That's kind of not advancing the ball. Then you have kind of the next layer of difficulty, and if you just kind of Google pricing algorithms, you will see an unending number of companies and services out there who will sell you pricing algorithms and pricing software and SDKs and all the other fancy stuff that'll help you price, get the best price on a website. And there, I think you have a new challenge, which is what happens if you and your competitor both choose the same algorithm and know that each of you is choosing the same algorithm. And I think there, it starts to get into questions of conscious parallelism, and it makes an enforcement case even harder. I think the kind of most difficult out there case is what happens if you use machine learning, which is effective, a tool that or an algorithm that teaches itself, right? It could run an A/B test or other forms of tests to try to figure out kind of how it should react to its competitors' prices. And in theory, and there are papers about this, that you can actually reach a collusive outcome where one AI, without any direction of any humans, figures out in pinging off the other bit of AI that the two of them can make more, maximize profits more by not responding to price decreases of the other.
Gotcha.
That is a theoretical. Go ahead, jump in.
So here's one question, because typically, enforcers in those cases are looking at the actions, the conduct of human beings who are making those pricing decisions, right? So you can infer, some intent based on the actions of human beings, but when you've got machines who are effectively self-governing and autonomous, making those decisions, in what respects does it make it harder to even utilize the conventional antitrust theories of harm to deter or to punish a machine?
Yeah, well, so that's a totally fascinating part of this, is that at some point, and you have to kind of go back into like the Turner-Posner debates of a while ago, at least from some of our perspective. But at one point, we decided that as a kind of choice of law, conscious parallelism is something that we can live with. So while from an economic standpoint, conscious parallelism, which is essentially just I'm sitting over here in my gas station looking across the street at your gas station, and I take into account that my change in price is going to cause you to change your price in a similar way because there's kind of just the two of us, that's legal. And we decided that's legal in our framework, not so much because the outcome is any more or consumers do any better or worse. In fact, it's kind of the same result as a collusive outcome, but because the kind of error in decision costs led us to a framework where it's very, very hard to prosecute conscious parallelism, and it's because it effectively turns the government into a price regulator. And that's the solution we settled on. So because we made that decision, we introduced this notion of kind of human agency into deciding when something is kind of illegal collusion or not.
Yeah.
And by introducing that notion of human agency a long time ago, we set us up for the world we're in, where if we can invent technology that by itself can reach a collusive kind of equilibrium, the law isn't currently adept at finding that illegal because there's no meeting of the minds, which is the core element. But robots their minds can't meet. It'll always be conscious parallelism. And that's, I think, it's the edge case, and it's really interesting. And I think there's been a lot of papers that, so while theoretically possible, there's been papers that kind of run simulation after simulation and effectively demonstrate that it's very hard for those collusive equilibria to be reached, even kind of under many repeated games. But the possibility is out there, and it's just a really interesting kind of thought question for antitrust.
So let me see if I can get this straight. It sounds like what you're telling us is robots really can't collude. Humans can use robots to collude. I mean, is that more or less right?
Well, it depends on how you define collude. So if you define collude as to have a meeting of the minds and you require those minds to be human minds, then the law does not currently find that to be kind of a Section 1 violation. The kind of policy question is, are we cool with that? And a long time ago, we decided that we were cool with conscious parallelism, and I think AI kind of reintroduces the question, and we're going to probably ultimately have to decide again.
What about I take your point that you can't have a meeting of the minds if you require robots can't have a meeting of the minds if human minds are required to meet. But what about a facilitating practice? In other words, what if could artificial intelligence or the algorithms behind pricing decisions, if shared publicly, if somehow made known in the market, could that be a non-Section 1 facilitating practice that could be found to be, unlawful?
Yeah, I mean, I think then again, you end up in kind of the same fact-based inquiry of what did the humans implementing these technologies know and think would happen? And then you're back to the same place you always were, which is you're reading their emails and their documents. And if they say in their document, like, isn't it great that, we all kind of, wink, wink, agreed to use the same algorithm, then you got yourself a Section 1 problem. Yeah.
That's fair. No. We've talked about situations where companies with AI technologies that drive pricing decisions in a market where they compete raise the issues of collusion under antitrust law. But let's talk about cases where you've got just one company, for example, a company with very high market shares, but one which uses AI algorithms to determine pricing or to determine output levels or to determine the direction of innovation. What kind of questions does the use of AI by large companies with high market shares? What questions do their use of AI raise under antitrust law?
So I think first things first. I don't think, and I'm happy to kind of be dissuaded of this, but I don't think anybody's, algorithm or machine learning tool is going to, in most cases, be the source of their market power. So if that's the case, right, then the use of a particular tool does nothing more than kind of their market power is what it is, and it can't do any more than they theoretically could have done with respect to pricing or anything else. And so then my question, if I had a client come to me and say, hey, we're thinking about using X, Y, or Z, pricing tool to kind of more effectively figure out when to price what at what level, right? Like on Tuesdays, I've figured out people are, willing to pay an extra penny for milk, and my AI is going to reset the price of milk.
Yeah.
So there, I think really the question from a kind of compliance and a risk standpoint for a client is much more, what is the algorithm going to reveal about your market power and your ability to raise price that might have been kind of less obvious in a world where you're dealing with just much more blunt instruments. So when you think about, if you're counseling a client and you say, if you're kind of wondering about unilateral effects issues, you say, well, what are your documents going to say? I think increasingly we should be asking our clients the question of, well, what are your algorithms going to say? What do you use? Have you done A/B testing? What does that say? How do you figure out when you can raise price, and what out there in your files and in your systems is going to help answer that question? And increasingly we see agencies ask for those kinds of things too in merger reviews and conduct investigations.
Great. So you've just helped us to segue a little bit into corporate counseling. So I know a lot of companies are increasingly trying to take advantage of the benefits that AI brings in increasing the quality of their goods in better matching demand with supply. So what are 2 or 3 of the critical pieces of advice you would give to companies who are thinking of using AI with respect to their pricing decisions and practices, or are thinking of deepening their engagement with AI when it comes to pricing and output? 2 or 3 pieces of advice you think would be important for them to really consider?
So the first one is to start as early as possible. So it is very, very hard. And when you think about, ultimately, you're talking about kind of software and systems design and database design. And when you design something in, undoing that can be extremely costly. So your approach to the use of AI, especially when it's consumer facing and has to do with pricing, antitrust has to be kind of part of that very initial conversation. I think then comes point 2, which is, we have developed as antitrust lawyers kind of a facility for training sales teams and executives and people creating documents on how to deal with AI. We are now in a world where we need to develop a sensitivity for a whole new group of people. And these are programmers and data scientists and people who have probably never thought about antitrust and how the things that they're designing could create antitrust risks for their companies. And that is a different conversation. And I think you need to kind of learn how to antitrust lawyers need to learn how the technology works, and then they need to learn to speak to people who develop technology, because it's a different world and a different set of objectives, and it's a new conversation that we need to get better at having. Okay,
fair. John, any questions?
No, and really is just trying to be practical. How do you get to those people who are designing the algorithms who just they just don't know?
They keep them in the basement, so you just got to go down there.
But go down a level. No, they just don't know what they don't know, right?
I mean, just kidding. Yeah, no, it's actually really hard. So I think this is first and foremost a challenge for really for in-house counsel is to rethink the people even that they're talking to. You need to be going to the head of the data science team and saying, hey, I want to talk to your team about antitrust. And they're going to say, why? I worry about data privacy and I worry about security. Why do I need to talk about antitrust? And one of the nice things is because of privacy and because of data security issues, those teams are increasingly used to having to hear from the lawyers. So it is a matter of inserting yourself as an antitrust lawyer into those conversations as well. But I do think it's really important if you have kind of a business person come in and saying, no, we have this cool new thing. You need to say, yeah, but who built it? I want to talk to that person. Because oftentimes you're talking about technology where you can ask the first 5 people, how does it work? And they say, I don't know, it just works. And sometimes you got to dig really deep to the 1 or 2 people who actually understand the really sophisticated, often statistical tools that are going into these things.
So given all of that uncertainty, do you think, and just putting the hat on of the enforcers, do you think the current antitrust laws are adequate then to really detect, to really deter, to really prosecute potentially anti-competitive behavior driven by AI when there's so much uncertainty among the lawyers, much less, the regulators?
So I think the first answer to that question is actually, in many ways, AI is giving a lot more tools to enforcers than they had before. I mean, so back to what I kind of said at the beginning, we now have kind of these data trails rather than paper trails of exactly how competitive interactions work. And that answers a lot of questions and can help us actually much more quickly resolve questions, even though usually when you talk about working with data, it doesn't suggest to people that it's a quick answer. Whether antitrust is adequate to kind of capture any potential abuse with AI, I think probably there is this open question of the edge case of the kind of collusive robot without the meeting of the minds. But all of the evidence currently suggests that is, while a super interesting theoretical question, highly unlikely to kind of permeate just the equilibrium that you need to get in a world that changes so quickly when you're talking about kind of online goods and everything else. I think it's something that could never or is more likely than not to not happen. That's a lot of nots.
Okay.
We should work through it, but I don't think it should keep us up at night.
And something that I think is maybe something to keep an eye on. In episode 18 of our Curious Amalgam, we talked to people who are using artificial intelligence to look for compliance blips. So what you're going to have is artificial intelligence looking after artificial intelligence. And so it's all gonna. I mean, it all can happen if really what you're doing is looking at data-driven decisions. Those data-driven decisions are all ultimately going to all happen much more quickly. So, I mean, it is if you don't set it up right, you're likely to be found out.
Yep, and that was your first point, Kelly.
It's a real challenge.
Yep. Alrighty.
Well, good, Kelly. Maybe we can shift gears a little bit. First, look, you obviously have enjoy talking about this and getting into this. What's fun about being a competition lawyer? Maybe even more. What's fun about being a competition lawyer who gets to think about AI issues?
So, I'd say about 6 years ago, I made the decision to move from DC, where I was kind of a DC competition lawyer, to the Bay Area. And the main reason was that I think that there's nothing more interesting in antitrust law than to kind of adapt the laws to new markets and new strategies for reaching customers and developing new products. And that, especially being out in San Francisco, is what is really fun, is just kind of always being on the forefront of the way people are kind of consuming and interacting with the companies they want to buy things from. And that's why I like being an antitrust lawyer.
All right. And what advice would you have for somebody who's maybe just coming out of law school, or maybe even thinking about going to law school, about how to get, what advice do you wish you would have had maybe coming out of law school?
Oh boy, that's actually a hard one. So I'm gonna revise the question a little bit, and I'm gonna get. So the advice I should have gotten when I came out of college was that I did not want to be. I thought I wanted to be an investment banker, and I failed miserably. And I hated every second of it, and I felt awful. And I think when I look at people kind of coming out of law school now, they're very concerned about failing or trying something and not liking it. And I think it's just really important to be attuned to what's fun and what's interesting. And that's kind of how I found my way into antitrust law. I just started following what was fun and what were the questions I wanted to answer. And I think, if that leads you to antitrust, that's wonderful. And obviously, I think that's the best place to be.
Well, and it's the thing that's interesting is I think a lot of people think that trying something and failing means failing. And actually trying something and having it not work out is actually okay, because you get
it's an opportunity to learn from it and try something new, try something different, try something better. No.
Yep. Embrace failure.
All right. So now the hardest question we're going to ask you today. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
So I already admitted to being obsessed with robot collusion, which is usually one of the weirder things about me. I think I told you before, this is a hard question. The best I can come up with is, So when I was growing up, I went to a high school that by historical accident had a paleontology museum. And I spent the better part of 4 years traipsing around Barstow, California and various Western states looking for fossils and otherwise living in the dirt.
Best fossil you found? Did you ever find a T-Rex?
No, I did. My best was an elephant tooth, which does not sound that exciting, but it was a pretty big deal.
I thought elephants lived in Africa and Asia.
Was this mammoth, maybe?
No, they lived in Barstow.
In the wild in Barstow.
There's just a circus elephant that had escaped or something like that? No? Okay.
Prehistoric circus elephants.
All right, well, let's go to our last segment we call Our Curious Hat.
And now it's time for the Curious Hat.
Okay, in my left hand, I have an actual hat that has actual questions in it. Kelly, because you're not in the same room with us, I'm going to ask Ricardo to choose a question, and then we'll ask you the question that he chooses.
Just so you know, I'm going to the bottom of the hat, Kelly. I'm not cheating.
All right, so this is question number 1. Question number 11, sorry. What advice would you give your 16-year-old self?
Oh, no. It's mostly fashion and what to not do.
I just want to make sure I got the answer. So you would give your 16-year-old self fashion advice?
Yes. Yeah, no, there would be way less kind of bootcut jeans and pleather.
Interesting. I probably could have used that advice as a 16-year-old as well.
that was not a problem I had, John, but it's good to know that about you too.
I had lots of issues, but
okay.
I might have you get in touch with my 14-year-old daughter who give her advice. But with that, I think we've come to the end of our episode. We'll see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.